Hello, good morning. I'm going to present on my midterm paper, which is on Tarasov versus Regents of the University of California. The title of the case is Vitaly Tarasov versus the Regents of the University of California. It was decided on July 1st, 1976 by Judge Dobrynar. Commonly known as Tarasov Rule, it is a hallmark decision in mental health field and public health. It made forward two important statutes, which is called duty to warn and duty to protect. The original decision was made in 1974 and amendments were made in 1976. The initial decision was made by Judge Donald Wright, and the second decision was made by Judge Dobrynar. Looking into the background of the case, Ms. Tatiana Tarasov and Prosenjit Podar were students at University of California, Berkeley in 1967. Podar was a graduate student and he met Tatiana at a folk dance class at their international house in their campus in the fall of 1968. They started to date but had different views about their relationship. Podar was very serious about his relationship with her. Tatiana told him that she was not interested to have an intimate relationship with him and she was dating other men, which led Podar to an emotional crisis and feeling of resentment towards Tatiana. He began to stalk her, even started videotaping the conversations. He started to neglect his health care, had crying spells, had disorganized speech and behavior. He gradually deteriorated through spring and summer of 1969. In summer 1969, Tatiana went to South America for a vacation, and Podar showed improvement in his symptoms. So with the advice of a friend, he went to a therapist. He went to see Dr. Gold, who transferred his care to Dr. Moore at Cowell Memorial Hospital within the university campus. Podar confided in Dr. Moore that he would kill Tatiana. Dr. Moore diagnosed Podar with paranoid schizophrenia, and he instructed the campus police officers to detain him. Dr. Moore spoke to his authorities there. He spoke to Dr. Yandel, an assistant director at the Department of Psychiatry at Cowell Memorial Hospital, and wrote a written letter to the police chief asking for their involvement in confinement of Podar. But the campus officers took him to custody, but after a brief detainment, the campus police released him with the promise to stay away from Tatiana when they thought that he was rational. Dr. Moore afterwards reported this incident to his supervisor, Dr. Harvey Powelson. Dr. Powelson said you should not put him in a 72-hour treatment facility and no further action should be taken on Podar. It was his decision. So Dr. Powelson requested the campus police to return Dr. Moore's letter and instructed to destroy all the evidence regarding Podar's visit. After the release from the detainment, Podar made friends with Tatiana's brother with the intention to kill Tatiana. He shared apartments with Tatiana's brother, and on October 27, 1969, he killed Tatiana in her residence by first shooting her with a pellet gun and then stabbing her. The original decision on the case was made in 1974 by Judge Wright under Penal Code 187. And the judge convicted Podar with manslaughter. The second case was put by the parents of Tatiana. They filed as plaintiffs against Regents of University of California. The parents argued that the psychotherapist did not warn Tatiana or her parents about the intention of the patient to kill her. They alleged that their failure to warn Tatiana and others who would have told Tatiana about an impending danger to her life is a breach of therapist's duty to exercise reasonable care. The defendants were the Regents of University of California. They called for action against defendants, specifically on charges such as failure to detain a dangerous patient, failure to warn on a dangerous patient, abandonment of a dangerous patient, and breach of primary duty to patient and public. So the alleged defendants failed to warn about the impending danger to the plaintiff. They alleged that they failed to confine Potter as per Lanterman-Petro-Short Act. They called for action against defendants specifically on charges on failure to detain a dangerous patient, failure to warn on a dangerous patient, abandonment of a dangerous patient, and breach of primary duty to patient and public. The defendant argued that they do not owe a duty of reasonable care to Tatiana, and they argued that the California Tort Claims Act protects them from any liability. The Supreme Court of California arrived at the decision that the mental health professionals have the duty to warn the victim of a potential threat by a patient, even if that demands break in confidentiality. Supreme Court saw that the therapist does owe duty of reasonable care to a third party if the third party is in impending danger of violence from the patient and they are aware of it. Supreme Court set forward certain responsibilities, such as warning the intended victim or others who would communicate the threat to the victim, notification of police, or ensuring to take any steps reasonably necessary under such circumstances. So we'll look into what is it, or the facts of the case. So Judge Tobrino looked at various rules and regulations at the time period to arrive at a right decision. So he looked into Dillon versus Legg. As per Dillon versus Legg, the defendants are liable for damage if their failure of duty, which includes all the considerations for protection, led to damage to a plaintiff. Second one was Rowland versus Kristen. In the judgment, Justice Peters said that a person may be liable if injury has occurred to another due to his lack of use of ordinary care and skill. In this case, the defendants did not use the ordinary care or skill to protect Tatiana. Third one was Heaven versus Penter. Justice Peters judged that a person has duty to use ordinary care and skill if his failure to do so may cause danger to a person or property of another person. Fourthly, he looked into Rodriguez versus Bethlehem Steel Corp. Mentioned that the duty to warn and duty to protect is a right that a mental health professional must abide by to protect the life of a possible victim of their patient. Just looked into Richards versus Stanley in 1954. As per this case, a person does not owe a duty to control the conduct of another person. But there are some limitations to this case. It says that if there's a special relationship between the defendant and the person who committed the wrong, the person who has the special relationship have the duty to control the behavior of the another. In this case, the therapeutic relationship between Podar and therapist is a special relationship which makes the therapist owing the duty to control the behavior of another. So, and the judge decided that because of the existence of a special relationship between a physician and the patient, the physician also has responsibility for the benefit of third persons involved. The judge also looked into Merchant National Bank versus United States. In this case, a patient from Veterans Administration was working at a local farm after the VA made arrangements for him to work there. But the farmer was not informed about the patient's mental background. So the farmer allowed the patient more freedom, which led this man to borrow the farmer's car and go to his house, and he ended up killing his wife. So the court decided that the VA was liable for the death of farmer's spouse because they hid the patient's mental health issues and background from the farmer. The judge Tobrino opined that defendants have a duty to protect the third persons involved, and he is responsible for the safety of the patient after entering into a doctor-patient relationship. Next, we looked into Evidence Code section 1014 and 1024. 1014 says we have to protect the privacy of a privileged therapeutic communication. But 1024 is the exception to the section 1014, which says that there is an exception to this privilege of therapeutic relationship. The privilege of confidentiality in the relationship can be broken if the therapist feels that the patient under his care is dangerous to himself or another's property. Another law the judge looked into was Principles of Medical Ethics by American Medical Association. The judge opined that sharing confidential information may be required to protect the welfare of the individual and community, as is mentioned in the Principle of Medical Ethics. Judge Tobrinor highlights that the protective privileges end where public peril begins. Another aspect they looked into was in re Lifshutz. It was mainly by Judge Clark. He dissented the judgment by Judge Tobrinor because Judge Clark said that and assuring confidentiality in a therapeutic relationship is required for patients to seek assistance, to come for full disclosure and for a successful treatment of a patient. Even though we know that the confidentiality is important, but certain times there is a limit to confidentiality where a third party is involved. So that's why Judge Tobrinor looked into it differently. Next one case they looked into was Johnson versus State of California. As per this case, the statutory section of the government code only provides immunity to public employees in matters of basic policy decisions. So the judge Tobrinor concluded that the defendant therapists are not immune from liability due to their failure to warn Tatiana, which led to her death. So he said that they are liable due to their failure to warn Tatiana or her parents regarding an impending danger. But they also looked into Government Code Section 856, which said that yes, the government officials does have immunity in cases of confining a patient and releasing a patient, and because the patient was confined but was released. So according to this section 856, the court determined that Dr. Powell's decision not to seek confinement for Podar was a right, and Powell is protected within the scope of immunity under the section 856. So he was protected. Another consideration for this case was if the police officers who released was liable. But according to the section 5154 of the Welfare and Institutions Code of the university, the officials in charge are not liable for civic cases or criminal cases if the patient they released at 72 hours or before did commit any legally liable actions. The judge thus held that the defendant police officers are considered peace officers and they are protected by the immunity under the institutions code. So they cannot be made liable, but it did have some good decisions regarding ensuring certain statutes such as duty to warn and duty to protect for future. According to Supreme Court decision, the mental health professional should warn identifiable third party who are at risk for endangerment by their outpatients, who has reported threats of serious harm and imminent nature towards a third party. Based on the coercive role, the legislature framed a complete statutory resolution of the rights and duties of both the mentally ill and professionals charged with the care and treatment of mentally ill. A comprehensive statutory regulation was effective on July 1, 1969. These statutory provisions provide detailed procedures for commitment. They provide regulations about the rights and responsibilities of mentally ill patients. They mention the duties and responsibilities and liabilities for therapists. It also led to Section 5321, which specified fine for unlawful disclosure of information. This law also led to 5328.1, which specifies disclosure to a member of the family that the patient is presently in the facility if the professional in charge feels that such release of information is in the best interest of the patient, or if they feel that the patient is physically ill and the family may be wondering where he is. In that case, maybe the professional have the option to reveal certain information, such as that this patient is here, but it also limits full disclosure about the patient's condition too. The title Tarasov Rule itself was codified by California legislature in 1985. The rule mentions that a psychotherapist has a responsibility to warn and protect the third party only if the therapist actually believes with reasonable certainty that the patient may cause serious injury to the third party who was identified in the disclosure by the patient. Tarasov rule was further expanded in 2001 to include threats disclosed to the therapist by the patient's family members after a murder-suicide incident in 2001. So yes, there was a murder-suicide incident in which the patient's father disclosed to the therapist that the patient was having homicidal ideation to this person, but the therapist did not warn the patient, the third party, but eventually the patient killed the third party, and which led to the expansion of Tarasov rule in 2001, which happened to include even the disclosure by the patient's family member as a threat, and the third party must be warned. So its impact on public health law. Yes, the mental health professionals have been required to warn and protect citizens who are potential victims of the patients, even though confidentiality of the patient was in question. The mental health providers could be sued if they discharge inpatients who are still violent, or if they are not able to control aggressive outpatients. Certain states with duty to warn statutes have certain intervention options, as we mentioned earlier about the involuntary commitment options, and what are the rules and responsibilities of the patient and the responsibilities of the therapist itself. So even though all the states do not have set statutes, it is said that it is a standard of care. Sadok, who is a psychiatrist, he mentions that he has a big book about synopsis of psychiatry. He mentioned that every mental health professional has a responsibility, even though it is mentioned in their state statutes or not. The mental health professionals must abide by this rule as a standard of care. That's what Sadok said. Looking into the limitations, I cannot call it limitations, because that will mean that protection of a third-party person is not right. But I would call that there are criticisms to the Tarasov rule. So the two main criticisms to the Tarasov rule is breach of confidentiality and predictability of nonviolent patient. So first, looking into the breach of confidentiality, as few health professionals at the time and even still feel that because of this rule, maybe all of the patients may not come to the therapist and may not confide all of the information, and some may hide it because they might get reported and they might be confined. So that is a breach of confidentiality is a major issue there. But if he is aware of somebody is in danger, the therapist has the responsibility to report in spite of breach of confidentiality. Secondly, the violent patient. Many expect the therapist or the psychiatrist to predict violence from a patient. It is not predictable. Nobody can predict. Some can say, yeah, maybe the violent tendencies, but nobody can say, yeah, maybe this person is going to kill that person unless the patient confides in you. So Everton, since the passage of Tarasov rule, therapists and psychiatrists have been looked upon to predict the potential danger behavior of their violent patients in the future. And there have been consistent research to show that mental health professionals cannot predict future violent behavior with considerable accuracy. So to moving on to the conclusion, Terrorism rule is intended to safeguard the public, and the decision by Judge Tobrino was wise, and he carefully evaluated the rules and cases of the time, and he even looked into medical ethics and medical textbooks to arrive at the right decisions. So the mental health professionals do abide by the statutes. So the psychiatrist does have the right to protect the third party if the patient discloses that information to him. Looking at the summary of the Terrorism rule, it highlights the importance of learning what information can be kept confidential and what information can be shared, and conditions for sharing certain information such as intention to kill somebody or potential danger to someone's property. If revealed to them. The mental health professional must abide by this law till day to ensure the safety of others threatened by their patients, and if they feel that the threat is serious enough. And thus, protecting a third party rose as an important aspect of confidentiality in therapeutic relationship between mental health professional and patient after this law. So this was an important hallmark decision in mental health arena. Thank you. Please email me your questions. Bye.